Presidents between 1997 and 1998. In 2000, he was appointed Minister of Education, and between 2004 and 2008, as I said, he served as Minister of Justice of Slovenia. Ladies and gentlemen, please join me in a very, very warm welcome for the Honorable Lovro Šturm. Thank you.
Thank you very much, Mr. Chairman, for giving me the floor. I would also comment and congratulate you for organizing this very important, scientific, and politically important summit in Ljubljana, a human rights summit. Now, in my contribution, I will deal both with Slovenia as well as mass atrocities against humanity. I will also talk about the legal norms on legislative measures preventing crimes against humanities and genocide. I will speak about Slovenian experience, and I will also mention the conditions and circumstances in Europe. I will go back into history, into Europe's experience with crimes against humanities, including genocide. Therefore, all comparisons that I will provide in my contribution will only be restricted to Europe. They will not dwell on other continents. Although in other continents there are grave examples of atrocities and crimes. Europe in the 20th century was the site of many totalitarian regimes, leading into a number of mass crimes we are dealing with today. Now, Slovenia is one of the rare countries in Europe and the only member state of the European Union that was exposed to all the three totalitarian systems of the 20th century in the European continent. Therefore, this contribution will deal with the historic and legal experience of Slovenia and its population in the sad period of history. Now, Europe stands on the sides of totalitarian systems. Today's region, an area of security, justice, and peace, comprises countries which, in the 20th century, witnessed various political, national, and ideological divisions, as well as violence unprecedented in its history. After World War II, which is also labeled as an eminent catastrophe of the 20th century, began a time that was marked with the economic crisis. It gave rise to dictatorships, and in some countries of Central and Eastern European Europe, this gave rise to fascist and national socialist totalitarian regimes. Since the October Revolution in 1917, the world also saw communist totalitarianism. Later on, this type of totalitarian system spread from the eastern parts of the continent towards other parts of Europe, of CEE and south and eastern parts of Europe. These parts of Europe saw a rising communist totalitarian systems, which was preserved until the end of the 1980s. The totalitarian regimes witnessed by Europe in the former century were strengthened not only on the basis of lies, but also on the basis of mass killings and murders. Today, we would call them crimes against humanity. All this was linked to a systemic and grave encroachment upon the basic human rights enshrined in the Convention on the Protection of Human Rights and Freedoms. That convention also includes the right to life. Many people were deprived of liberty and life without a judicial process, without having a fair trial. Those who were against the totalitarian regime and its legislation were suffering from torture, inhuman and degrading treatment, as well as forced work in concentration and work camps. Totalitarian regimes encroached upon the freedom of expression as well. One of the fundamental characteristics of totalitarian regimes is also discrimination. Discrimination based on gender, race, color of skin, language, religion, ethnicity, as well as social background and political conviction. I have described a number of different forms of totalitarianism. This, however, and unfortunately, is not only a description taken from a handbook in philosophy or legal history. Unfortunately, this is reality witnessed by Europeans born before the fall of the Berlin Wall, either directly or indirectly, on our own skin. Every country has their own experience of the 20th century. Some countries did not even go through a totalitarian regime. Some countries have experience with a single or even two totalitarian regimes. The particular feature of Slovenia is that amongst the EU member states, Slovenia is the only country that faced in its territory all the three types of European totalitarian systems. Many European countries have suffered greatly in the 20th century. Very often there were conflicts among these countries, but all of them have one thing in common: a large number of victims of totalitarian regimes. The respect and the general and universal right to personal dignity requires absence of discrimination and equal treatment for all of them. The right to dignity is one of the rare, is not the only fundamental personal freedoms that does not stop with the death of an individual. The right to dignity should be respected even after an individual's death. Now, the European Court of Human Rights, as we know, recently in the Kononov case, reconfirmed that when it comes to victims, we cannot make differences. All victims should be treated without discrimination. They are all equal. In 2008, the Council of the European Union adopted a declaration on the public European processing of genocides, crimes against humanities, and war crimes. This was also described in a collection of papers prepared by the Slovenian presidency of the EU Council and the European Commission. In the year to follow, that is in April 2009, the European Parliament adopted a resolution on the European awareness and totalitarianism. Europeans today are aware that violence and discrimination do not have a place in a free democratic society. Only with a critical knowledge of violence and the injustice caused in the previous system by totalitarian regimes in the European soil can we understand the present, and only in this way can we hope that the former century will not be repeated. History must be accepted as it is. Only in this way will we once and for all learn that no violence based on racial affiliation, the color of skin, religion, political conviction, or national membership can bring mutual respect and peaceful coexistence. We are all aware of the grave crimes against humanities that were committed in the 1990s in the area of the former Yugoslavia, in southeastern Europe. These atrocities confirmed our resolution, namely that we need to keep investing our efforts into preventing such atrocities at the national and international level. Let me go back to the Slovenian experience. I will try to describe them in greater detail. Slovenians in the past, in the former century, were both victims as well as active rebellions against all the three totalitarian regimes. The fascist totalitarian regime started very early. It affected the parts of the Slovenian nation which remained after the First World War outside the former Yugoslavia, that is, in Italy. The fascist regime acted against the Slovenian nation, and the Slovenians were the first to suffer from the fascist justice or the fascist judicial system. As you know, the fascist regime caused very serious and grave crimes also outside Europe, but I will focus in my contribution to the European ground. A high number of population were extradited. They had to leave the territory they lived in. They were expelled into other countries. During the Second World War, the National Socialism rose, causing mass expulsions of the population, massive concentration camps, and what was new, there were revenge actions taking place, not only against individuals, but also against whole numbers of villages and settlements. The number of victims of National Socialism in Slovenia was about 20,000. After the Second World War, Slovenians witnessed communism and what I would call Titoism. During the period of Titoism, there were massive expulsions, resettlements, a number of work and concentration camps operated, and there were mass murders of the Slovenian population committed. From the end of World War II up until January 1946, at least 100,000 people were killed, including women, injured persons, and disabled persons. Of which Slovenians accounted for 15,000 people. The rest were not of Slovenian nationality. But even this number, 15,000 Slovenian people, represented 1% of the Slovenian population. These were the victims of crimes committed under the communist Titoism system, and they represented 1% of the entire Slovenian population. The mass killing sites are spread all around Slovenia. The investigations carried out in recent years showed that the number of mass murder sites were as high as 600 all across Slovenia. These mass murder sites were dispersed throughout Slovenia. Those that are most known are the massacre sites in Maribor, Tesno and the surroundings, the town of Celje and the surroundings. In particular, known and horrific is the mining site in Laško that included not only male but also juvenile and female victims. There are massacre sites in Ljubljana and the surroundings, including the site of Kočevski Rog. Now, these are the major and biggest mass murder sites. Now, understandably, the legal codification and the legal treatment of crimes against humanity and genocide is based also on the UN Convention adopted in 1948. In Slovenia, in the former Yugoslavia, this convention was not completely codified. It was codified to an extent, however. In the then Yugoslavia, the general attitude was expressed in the Federal Penal Code. Namely, according to the general attitude, this was supposed to be a convention that can only be used for the future, ex ante, and not retrospectively. This convention refers to some crimes that are not subject to the limitation of statute, the statute of limitation, that is. Does the convention apply to the horrific acts committed in the area of former Yugoslavia, including Slovenia? Now, when this question arose, it gave also rise to the dilemma on the regulation in legal terms of sanctioning of crimes against humanities and war crimes. At that time, it was rather difficult to speak about genocide because it was not yet encoded in the law. The next important question was what legal tools were to be used in such cases. The Slovenian legal doctrine gave rise to the following two positions, which do not contravene each other, they complement each other. I will go through the affirmative law, first of all. On the one hand, we have the criminal code adopted by the Republic of Slovenia It has been modified several times. Now, this code includes in whole all the principles and rules of international law regarding crimes against humanities. It follows on the convention, and in certain cases, the codification is even wider than the convention. The last modification that widened the definitions was put in place in 2002. Let me give you some specific examples. A crime against humanities and international law, first of all, deals with examples of traditional genocide, if you will. It reflects, word by word, the convention. And I quote, "Anyone who, with a purpose to completely or partly destroy any religious group, directs the killing of its members or causes grave bodily harm or mental health, or anyone who, with the same purpose, causes that someone finds themselves in a life situation that leads into the destruction of this group or leads to measures and action preventing birth within a group. Anyone who forces children to move into another group, anyone who with the same intent commits one of these crimes shall be punished with a sentence of prison of up to 30 years. Now, this, I believe, is the widest codification of the convention. And what is more, we have a new paragraph here in the Slovenian code. It says that anyone who commits the crime referred to in the previous paragraph against a political group or another group shall be sanctioned in the same way. As you can see, this is a widening of the legal norm foreseen in the International Convention. It is extending to groups which, at the time the convention was enacted, could not have been included in the convention because of the disputes among some of the groups supporters of the convention. Just limiting the crime to a national, ethnic, religious or racial group has turned out to be too narrow in Slovenia. And if we look in comparative terms to the events happening outside the European continent, it also seems to be too narrow. The Slovenian type of codification can therefore be interesting also for some other countries, because it leads into efforts to codify this substance, first of all at the national levels, and then maybe at the international, global level. The criminal code also sets out that these crimes are not subject of the statute of limitation, and they can be sanctioned, they can be applied retroactively. This is a norm that goes beyond the norm arising from the law in general, saying that a crime does not exist unless it is defined ex ante. The reasons of natural law here are stronger than the principles of legal positivism. Let me describe a case that we had before the Constitutional Court in Slovenia in 1993. At that time, the Slovenian Constitutional Court decided on the possibilities of pardon to individuals. There was a case of rehabilitation or pardoning of individuals on the basis of a legal act, which at the end of the World War II created the destiny of many people in the territory of Slovenia and the former Yugoslavia. I'm speaking here about the so-called decree on military courts or martial courts enacted in 1943. The decree on martial courts was later confirmed by the then National Assembly in 1945 in Belgrade. In its legal nature, the decree on martial courts was a legal act that included both substantive, criminal provisions. It also included procedural norms and provisions and organizational provisions. This is unusual, but this was the case at that time. So in the case before the Constitutional Court, there was this question whether this act can go through a legal test when it comes to pardoning and rehabilitating individuals. And if there is a rehabilitation of individuals, can this lead to a trial? Now, the Constitutional Court, when deciding upon this, used the so-called Martin's Clause. The author is Martins, a very well-known lawyer. It was used in one of the first Hague Conventions, in actually Hague Convention number 4, dating back to 1907, and it entered into force in January 1910. Yes, I will finish shortly. The court decided as follows. Where we have cases that are in principle against the international criminal norms and laws, the decree on martial courts cannot be applied. The court also resolved that the decree on martial courts, which was supposed to be a unilateral legal act to be used only by the winning party, this cannot be an act used universally. In this respect, the decree could trigger the procedures foreseen in it. Now, in Slovenia, there were a number of judicial court cases, that is, where the courts did not decide to apply the decree on martial courts to begin a legal process. The courts used another method, namely they used the new Slovenian codification dating back to 2002. This new codification allowed the prosecution of crimes also in cases they go back to the 1940s. The new Slovenian codification in certain cases does not recognize the statute of limitation and allows for court procedures in line with the International Convention properly expanded in the Slovenian codification. The court extensively justified its decision and opened the door for criminal prosecution. Later on, the procedures were stopped, well, some of the procedures were stopped because of a lack of evidence. Let me propose at least two conclusions based on what I have said. The first conclusion. The beginnings of any court procedures in the crimes we talk about, crimes against humanities, must be started immediately. Any delay makes further realization of legal procedures very difficult. Conclusion number two that I would like to propose. National legislation is also very important. The awareness must be raised about the need to extend national codifications, in particular in the case of genocide. Genocide should also refer to other groups, not only to those that are enshrined in the definition of genocide. Namely, there can be genocide happening against social or political groups. There may also be some or non-defined ad hoc groups against which systemic violence also incurs. Thank you very much for your attention, and I'm sorry if I have extended the time that I had on my hands. But quiet.
Much, Dr. Šturm. I wish we had more time to learn more from you and the tremendous experience that you have, actually, in particular with Slovenia. And I think it became clear from your lecture also what the international community can also learn from the experiences of Slovenia when it comes to these issues. So thank you very, very much, Dr. Šturm, for that presentation. Could I ask for a second round of applause, please, for Dr. Šturm? Thank you. You can stay here. You can stay here.